Good afternoon, this is Sean Golden with Golden & Golding. As we come to the end of 2022, got a lot of questions each year about FBAR, so why don't we just kind of work through what the FBAR, where it is now, some of the common questions we've gotten heading into the new year, a few concerns for taxpayers, and take it from there. FBAR, again, right, it's the form that's used to report foreign bank and financial accounts. Technically, it's on a FinCEN Form, Financial Crimes Enforcement Network. It's not an IRS form. It's not under Title 26, although the IRS does enforce it. It includes all different types of accounts, investment accounts, bank accounts, certain life insurance policies, pensions, things of that nature. It's filed electronically. It's used to report the annual maximum value. If the same money's been transferred into 3 different accounts, well, you report all 3 of those accounts, even though you're triple reporting the money. And that takes me to the first thing I want people to always remember. The FBAR is not necessarily the total value sum of all of your money overseas. It's just a value, the maximum value in the accounts that you're reporting. And so there can be some double counting that happens. The key issue is with non-compliance, it can lead to significant fines and penalties. For some odd reason, the IRS really likes to enforce this. Since it's a Title 31 and not a Title 26 issue, it's handled differently than your general tax scenario. You generally don't go to tax court for the FBAR. If anything, you'd have to go to federal court, district court, court of federal claims, though you do get an opportunity to appeal it. But let's work through some of the issues that have happened in 2022. Some cases, right? Some cases discussed. The first one is Hughes. Hughes was an interesting case. But the main takeaway, I could bore you all day with it, but the main takeaway from Hughes is that in a situation in which someone is non-compliant, it doesn't mean that they're going to be willful the whole time. It doesn't mean they're going to be non-willful the whole time. In this particular case, the court found that there were different facts in different years. And so in some years, the taxpayer was found to be willful. In some years, found to be non-willful. One of the key components of the ruling was TurboTax and whether they're using forms mode and interview mode. But the takeaway from Hughes, as you're heading into the new year, is that if you're not compliant in prior years, it doesn't have to be linear the whole time. It could be part willful and part non-willful. Another very important case was the Rahman case, Rahman. In this case, over the past few years, the IRS has hit home that, hey, if they think that you're willful and you're submitting a willful certification statement, I mean, you're pretending to be non-willful, but if the IRS has facts that you're willful, they've spoken to third parties, maybe an ex-business partner, a whistleblower, ex-spouse, that type of situation, and they believe you're willful, well, you're not guaranteed non-willful protection. They can go ahead and pursue you for tax fraud, for willfulness. They can even go after you for criminal. So that's something to keep in mind. Another important case was the Flint case. This was it was a creative case. It was a situation in which after submitting the streamlined procedures, which are procedures used to report prior year FBAR in which someone claims to be non-willful, they get a reduced penalty, 5% Title 26, miscellaneous offshore penalty, or penalty waiver if they qualify as a foreign resident. The IRS came back and claimed they were willful, and they took lots of different positions. But one position that stuck out was that by entering the streamlined procedures and receiving an initial acceptance through the processing, does that mean the IRS has agreed that you're non-willful and that you've entered into a contract that they cannot come after you for willfulness? Of course, that's not the case, and the IRS said no dice, and the court agreed. And so just because you submit to the streamline, and even if you get an initial acceptance, does not mean that they can't come after you later for willfulness if they think the shoe fits. Some additional issues, you see Bittner come up a lot. With Bittner, what's going on is that for non-willful civil violations, the Supreme Court is determining how the penalty should be issued. Should it be per form, or should it be accounts? So if you had 10 accounts on the form, do you get a $10,000 penalty, or can you get hit per account per year? California says one form. I believe it was Texas says per account. And so Bittner, that case, the Texas case, is up at appeal. Boyd is the California version of it. Another very important issue, though, not to be overlooked in Bittner, is that there were a number of unreported accounts, I think numbering 40, 50, or 60 and there was a significant amount of money. And that the court still found that he was non-willful. So a takeaway, and I've been telling people this for years, as has my team, it is important to always keep in mind that just because it's a high value, just because you have a number of accounts, that does not in and of itself make you willful. Okay. When it comes to willfulness, it can be reckless disregard or willful blindness, so you don't have to have actual knowledge or actual intent. They can use those lesser forms of willfulness, and the IRS can still hit you with the same penalties as if you were willful. If you're out of compliance, another final takeaway is that proactive action, going through one of the amnesty programs, is a benefit. It can help limit or eliminate penalties. There's lots of different programs. When you're going through amnesty, you get to write the narrative, right? You get to go first. You get to present the information with your cast of characters and formulate how the story will go. Whether the IRS accepts it or not, that's something different. But versus playing defense on an audit, right? They've already assumed that you're a bad person. Various different programs. If you're willful or you just can't certify under penalty of perjury that you're non-willful, you have the voluntary disclosure program. If you're non-willful, you have a lot more options available to you. You have the streamlined filing compliance procedures, domestic and foreign, depending if you're a U.S. resident or not. You've got reasonable cause and delinquency procedures. We've been handling FBAR cases for many years. We've got a ton of information available on our websites. You can always reach out and schedule a reduced fee initial consultation if you think it's appropriate to your matter, and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day. Happy holidays.